in equal shares.
Indeed.
Within
2 weeks?
like is it okay? How much time?
2 weeks, 2 weeks.
No, 1 day. 1 day. We will look for you high and low. We make efforts. Now you want it in 1 week. Make it reasonable, please, Council. Within 2 weeks, application is disposed of. This is 55.
Great, extremely great.
All the other matter which we had highlighted, 55.
55.
Yes, who's appearing in 55? Yes.
55 for the respondent, my lord.
55. Give us a moment. Just pulling out the file. Just give us a minute.
I'll file the detailed reply, my lord.
As per the direction, we were required to give him the demand draft, which we have already given, but he refused to take it.
Reason, what is the amount of the demand draft?
Even my lord.
What is the amount?
22 lakhs.
At least take the money coming your way.
My lord, we have taken they have given me, I have taken, my lord.
He's saying you've refused.
No, but as per my instruction, the amount has.
You want to give another 20, we are okay with it.
We'll give it tomorrow. We'll call.
He's saying he's received it.
He received it.
Then what are you saying? He's not taken
He
it.
has to vacate my shop. Yes.
Now tell us.
Yes, my lord.
What is the matter? Why is it that you're sitting pretty after the money's come your way?
Not in that shop, my lord.
Where are you? So we'll direct breaking open of the lock and taking possession. If you are not in that shop or whichever shop.
That's why the reply is needed, my lord.
No reply. Make your point now. Aren't you lucky that we are hearing you in a matter of contempt of this nature? You're violating the order passed by the court.
I have give it 5 minutes time, my lord.
You take 10. We are okay with it, but we are not giving you time. Why did you not comply?
Property, my lord, which is in 2 parts, my lord. One entire property was initially mortgaged by the Bimla Devi. Thereafter, my lord, front portion of that property, my lord, has been entered into agreement with the respondent container herein, my lord. And for that, my lord, I paid the amount. I took that property, my lord, and up to this honorable court, my lord, they have lost the SLP. Now the execution is pending for taking the possession, my lord.
Read the order of 1/8/23. All proceedings come to an end here and now. 1/8/23. We are on 1/8/23.
Property of total measuring 92 point odd scale yard, my lord. Out of that, my lord, this proceeding is called 70 scale yard, my lord. And for the remaining 22 scale yard in the shop, my lord, for that they entered into agreement, my lord. I filed the suit for specific performance.
Are you, 1 minute, are you saying that the SLP was only in respect of part of the property and not the entire property?
Please.
Where do you get that from?
That's why I filed this.
Whatever is here. You don't need to file anything.
You see the para 7, it says it is.
Para 7 of
same order.
our order.
1/8/2023. It is clarified that in the event the petitioner is in possession, why this was recorded? Because according to them, they had never had a possession. It was specifically on my request, this para was added, if they are in possession. Now, after 1 year again, they are saying, we are in possession, but that is disputed. So that cannot be entertained right now. And they should have vacated. Otherwise, we would have.
Yep, we are. It's a fit case of for where we should ideally take action against, send you behind bars. How old is your client?
On Monday.
How old is your client? Monday, no. Friday is good enough for you. No Monday. You should have come ready with instructions, knowing that you were in hot water.
As per my instruction, my lord, this is property in 2 parts.
You break open the lock and take over the possession.
That's the only way.
Take down.
We'll direct the
Direct police assistance.
SP concern.
Take down. The present petition has been filed. No suggestions. Matters over. Present contempt petition has been filed by the petitioner, stating inter alia that the respondent is in gross contempt of the order passed by this court on 1st of August 2023. Stop. On 1st of August 2023, a limited notice was issued in the present matter on, it was recorded as follows. Reproduce the order. Full stop. Learned counsel for the petitioner states that a sum of rupees 20 lakhs,
22 lakhs.
22 lakhs has been paid by the petitioners to the respondents in terms of the order recorded. He says it. You have paid it.
I already paid it.
Yes.
But yes, you said that he has not accepted it.
Initially, but now he is saying he has accepted it.
Has been paid to the respondent in installments as recorded in para 4 of the aforesaid order. Despite the same, the respondent is not, respondents, is it one or more than one?
Only one, my lord.
Respondent has not handed back, is not handing over possession of the subject premises to the petitioner. Learned counsel for the respondent seeks to raise a plea that the subject premises is that he's not in occupation of part of the subject premises, no?
Yes, my lord, there is.
And only in possession of only another part. This
That is
aspect,
Not the
which
subject
is not the subject matter of the litigation between the parties, full stop. Say that, where is your undertaking?
My lord,
Where was your, was there an
Because
undertaking?
they are
Where?
undertaking that they will pay the amount.
What about your handing over?
And for the handing over, there is no direction for.
Therefore you are sitting
Well,
here.
my lord,
So
I-
that,
In 1 month.
so that we decline to entertain any such excuse sought to be offered by the respondent if the respondent does not hand over vacant peaceful possession of the entire property, subject matter of the present litigation, within 1 week from today, the petitioner shall be at liberty to seek police aid for breaking open the locks of the property and taking over the possession thereof under, I think. Under the supervision of the
Charistina.
huh,
Charistina.
under the supervision of the court bailiff, this order shall be presented by the petitioner before the trial court for appointment of a bailiff and for police aid for execution of the execution thereof. Full stop.
Judge, must request, my lord.
Yes.
That is this, my lord, that the litigation, the case which is pending for that part of which they are asking for the possession, this order will not affect that
We
litigation.
have clarified everything will go.
Now everything.
Everything will
My
go.
lord, there
Next,
is a
please.
second case.
Yeah, that's your version.
They come
So
to-
sorry.
on
That's
the-
your-
Special
we are not.
petition was dismissed,
No,
my lord.
we are sorry.
The special petition which they had filed, my lord, seeking cancellation of that agreement to sell for that part of the property, that has been dismissed, my lord.
This is the first time we are hearing part 1, part 2. It was
Next.
never argued.
Next.
And never even discussed.
Next matter for the board.
Petition, my lord.
Yes, item 59.
Very much.
Not being present in the last year of your files and mediation minutes. Lordship may just see the order of last 15/3/2024. The respondent was supposed to deposit 50,000 in the registry upon physical appearance. 15/3/2024 minutes. Para 3 minutes.
Just a moment. What happened in mediation?
Mediation minute on 3 dates, it was there. Lordship may see the interim order minutes, interim mediation report. Mediation was held on 4.
Whatever it happened, what's the consequence of that
Consequence
mediation?
12 months. Physically, he was asked to come physically pillars on 17/5/2024. My client was there. She came from Nagpur, but he did not turn up deliberately. So
He has not made the payment also.
Not
Has he paid that amount?
My lordship, I communicated in my lordship. It is a legal matter. He has having saying that it is hard.
You are the legal aid counsel appointed by the legal aid.
He
Yes.
is saying that I am paying 3,000 per month maintenance fixed by the trial court. I am not having so much capacity to settle one time settlement. I asked in the court has directed.
All right, then we take the matter. We take the matter on minutes. Take down. The learned counsel for the parties state that though the parties were referred to the Supreme Court Mediation Center for exploring the possibility of their arriving at a one-time settlement, the same has not resulted in a settlement. So that in view of the aforesaid submission, the matter shall be taken up on merits, list and fix the date.
In the meanwhile, he is having a gym lots where he is.
Nothing in the meanwhile, today it's only directions. Next. Whatever you have to file, please file. Please file. We are in directions because you didn't appear. Blame yourself for your absence. You're lucky we didn't dismiss it. Yes.
At least the payment should.
Counsel, we have said there's no settlement, we'll have to hear it because he's not willing to pay anything to you. Right? If he was willing to, what could be better than that? We appreciate it. Yeah, appreciate.
I
You filed an application for interim?
I'll file minutes.
File an application.
File an
Pass an order.
application, we consider that. But today we can't do that in the absence of any.
Can you permit to file the time, order also, madam?
Whatever you want to file, nothing is stopping.
Rejoin the minutes to his counter.
So that if pleadings are not complete in the matter, then the pleadings may be completed within 4 weeks. Yes, 60.
As per the previous order, petitioner filed an affidavit. I want to file a response to that.
When was the affidavit filed?
16th May. I got it because the problem is that my inspecting council's office got flooded. So they disturbed, they could not occupy the.
That is recent. Nothing happened after 16th May till now. Sorry. Yes, ask you. But why was it in directions? Why was it in directions?
And the affidavit, placing all the pictures regarding the flat, it is in habitable condition. Now they are disputing, we have received one email. It is saying that there are certain things like the lock is not opening and there is some difficulty in opening.
Where are the photographs?
In the affidavit.
Affidavit. Let us see the affidavit. Let us see the affidavit.
There is no completion certificate till.
1 minute, let it complete. What's the hurry? Yes, please.
Yes.
Let us see your photo, the photographs you're referring to, of the flat that is off,
Yes.
to be allocated to.
Yeah, right.
Yes.
Everything has been, it is ready.
See, 3 photographs, because other photographs are of the general building project.
Yes.
Only 3 photographs you filed at 9, 10 and 11. That doesn't give the whole picture.
Yes.
That's all.
Not
And then the lift. How does it help you?
only part
Common passages.
of the.
There are more than 20 pictures, everything is in.
Okay.
Outside and outside, including toilet photographs are also there.
Okay.
This page 15 and then 16 and then balcony is 17 and then 18.
क्या करें संदीप? Photographs से तो पता नहीं बस.
Whether you got the occupation certificate, please?
Yes, we have applied. We have
Applied.
Yes, we have-
Applied means what?
In April. Can you see the last pages of this affidavit only? Can you see page-
We had said on 8/4/24 that you were granted last time of 4 weeks to complete pending task and make the flat habitable with a completion certificate.
Completion certificate without it.
Where is the
How is it
completion
task
certificate?
complete?
Page 26.
Oh, tell us orally. Have you got one or you've not got
Yes,
one?
we have applied. inspection.
Applied is
Applied.
not the point.
We have applied well within in April itself.
What is the status of the completion certificate?
They have to get to issue because.
When were you supposed to apply it? What was the date as per your agreement?
It was.
When were you supposed to procure it? Please.
It was there.
Then we paid the
There
entire.
are certain things which are.
Oh, certain things.
Yes. I'm coming.
Sorry, we will not insist that he takes possession till you give a completion certificate. Produce a completion certificate, we'll direct them to take possession.
Even.
Why should they take a possession of a property where they can't occupy in the absence? Take down, direct counsel for the
I made a
petitioner.
letter to them saying that for the delayed.
Now, please permit us. Then an affidavit has been filed by the petitioner along with photographs of the project and the flat in question. We have specifically inquired from learned counsel as to whether the completion certificate in respect of the subject project has been received. Learned counsel submits that that on 8/4/2024, this court had granted last opportunity to the petitioner to complete the pending work in the flat in question to make it habitable and procure a completion certificate. It is submitted that a necessary application for obtaining a completion certificate has been submitted to the authorities, but the same has yet to be released. Stop. I'd say that he seeks how much time? 4 weeks time for filing the copy of a completion certificate. Say that in the meantime, the respondents shall visit the subject premises.
You were saying something about what
Because compensation.
compensation.
Later on, first you go and see whether it's habitable.
2008 I paid the entire.
Yeah, you're right, but at least we'll record your submission without prejudice, but you at least visit it and see what is missing.
It may be recorded.
What date should we fix for your site visit? Where is this project?
Next week.
Where
Next
is-
week we will do that.
Say that.
But, this may
Both
be-
parties shall visit the flat in question on a convenient date next week. Shall we put it on 10th Saturday? On 10th at 11 a.m. The parties shall meet at the spot and site inspection shall be conducted So if the respondent is at liberty to file an affidavit, notes affidavit, liberty to point out the lacunae and deficiencies in the flat, which shall be, if any, which shall be duly addressed by the petitioner. An affidavit shall be filed in this regard by both sides. The submission made by learned counsel for the respondent, that the respondents are entitled to compensation for the delay on the part of the petitioners in handing over the flat in question, shall be considered on the next day.
Great, very good. Obliged.
Yes.
Very good.
Mrs. K. Varghela has been regularized.
Just give us a moment, please. He's pulling out the file. Yes.
Appearing for the respondents.
Other
My
side?
I'm appearing for the respondents, Union of India.
Yes. Very well. Yes.
Junior has been regularized and petitioner is senior who is fighting this legal battle since 2004.
Yes.
This is the first order of tribunal in favor of petitioner. I want to read page 36 notes in favor of.
The impugned order is a order which has been upheld by the High Court. So there are two courts holding concurrently against you, right? Focus on that.
Page 36 notes. We accordingly dispose of this OA by giving direction respondents to consider the case for conversion to time on the basis of this 1992 circular and other orders, if any, on the circular.
It's okay. On 12/9/2004, your application was rejected. You came to the High Court in 2005. Come to that. Much history is there after that. All that is over. Right?
Thereafter, Lordship, respondent is rejected without.
Yes. Yes, they have rejected. That's why we are asking you, why should we interfere?
Your
with the ground?
argument regarding discriminatory treatment,
Yes.
how was it dealt with by, please tell us, where was this argument made before the High Court and how was it dealt?
Dealt with.
Last time your Lordship asked the respondent
Yes.
and counter affidavit. They don't find counter affidavit.
Forget it. That's there. Okay. All right. You make your point on that, not a rejoinder counter, impugned judgment, your argument.
Lordship, main point, your Lordship has passed this order.
Which order? Which order?
You are referring to K.M. Vadela's case? What are you referring?
That is 27th February 24.
Yes, Lordship, yes. Learned counsel for the petitioner brought the last paragraph 3. Learned counsel for the respondent state that she may be permitted to file an affidavit. In this regard, an affidavit we filed explaining the circumstances in which Mrs. K.M. Varghela was regularized for not giving the same benefit to the petitioner.
Right.
in doing so.
Right.
Thereafter, they have filed a counter affidavit.
Yes.
And I am filing a rejoinder.
So what have they said
Lordship, there are 15
of their count? No, not wrong. Let's see what they have said. Right or wrong is a different matter. What have they
They have
said?
explained.
Come to that. Paragraph 15, page.
15 notes.
In their counter, there's no paragraph.
Page 13. 13.
Internal duty.
Yes, internal.
12 notes. Volume 2, page 12.
Affidavit on behalf. Yes, okay.
It is respectfully submitted that in compliance of the order dated 27/2015, passed by the Honorable K in OA number 51 of 2013.
Selected by DPC.
Srimati K.M. Varghela was selected as MTH during DPC, whereas the case of Srimati Ushaben Joshi was rejected by both the Honorable K as well as by the Honorable High Court. This is wrong, Lordship. In 2000.
Respondent, what was the procedure before DPC for which K.M. Varghela was selected as MTS? Tell us.
My lords, I'll just point out, my
Was
lords.
it DPC conducted for all similarly situated employees?
My lords, yes, it was.
Was
My lords, let me just
the
lay down
petitioner considered?
My
Was the
lords,
petitioner
let me
also?
just lay down the timeline. My lord petitioner was not considered for a
What?
reason because the DPC took place after the rejection order came by. So the rejection of that consideration pursuant to the first CAT order was on 29/12/2004. At that time, and then the KM Waghela, she got her order by the CAT in 2015,
When was the
28/7/2015.
DPC conducted?
My lords, DPC circular is at page
No, tell us the date. We are not turning
24.
pages.
Ma'am, this was in 2017. So vacancies were notified in 2016 and the circular came about in 24 January 2017, which was well after the rejection of her consideration.
Yes.
Lord, see, both are same in one office. She was.
It's not a question of being in the same office. We are just asking it by the time your case was over.
Same casual labor, both are. And all rule are applicable to both counsel. She is junior, she is
What,
joined.
on merits, Ms. Verma, what is the difference in the case
Between
of
petitioner and KM
Waghela
Waghela.
merits? On merits.
My lords, the simple submission, as per the instructions that I've received, is that she is a part-time worker. She's not worked more than that. And
KM Waghela also
What
part-time.
about
my
Waghela?
lords, I agree, my lords, but the only instructions that I have received
Then
is
we
that,
don't see why, how will we be able to
my
sustain
lords,
the
and I leave it in your hands, my lords, hands.
You are in very unsafe hands as far as you are concerned. Right? Right. So take it as read. We pass a small order and allow it and dispose it of. Make sure that the petitioner joins duty by within 4 weeks. Okay?
These are at par with Waghela.
And for all purposes at par.
She's already working.
She's working, but she was to be so
We regularize,
discharged and regularized.
regularized.
Okay?
We have got the order of Waghela on record. Yes, so that's an admitted position. Okay.
Next.
Obliged, my lord.
Please, Your Honor. Appeal for the respondent was in terms of the last directions.
Yes, just a moment. Page 35. Yes?
Because we have filed a response to their additional affidavit.
The period for which the respondent was before Bailiff would indicate that the reference was entered in 2002, and since for 3 years before that they were in negative, net worth was negative
Right.
and the cutoff date was 31/3/2006, and thereafter as late as 2008 they came out of this red page and they showed their net worth as positive. So from 2000 to 2008, this respondent establishment was all through before Bailiff and was under a scheme from 2003 onwards. So the tribunal rightfully reduced from 25% to 5%, because the entire period under inquiry was from 2000 to 2010. And secondly,
We are now skinning them.
Yes.
Second proviso to section 14B, if my lord may kindly have page 22 of the paper book. The second proviso of section 14 capital B of the Act has a very significant and in between. I will just read it. Provided just before my lords, just after 9, which is footnote 9, at page 22, provided
Just looking. 1 minute. Page 21 minute. Page 22, section 14B. You're reading. Where are you reading?
That was the second proviso right after 9, my lords. There's a footnote subscription 9.
Yes.
Provided further that the central board may reduce or waive the damages.
You're saying that there's no sanction of a in the instant case. That's all? That's your case?
The very ingredients of the proviso are not satisfied. The word is there is and a scheme has to be sanctioned by the board. In this case, admittedly, no scheme was sanctioned. And even otherwise.
But they're paid interest now. What is the amount of interest? What is the extent of interest? 5%? They paid 12%. You want 37%.
This remedy is separate manuals. Either I could go to Central Board of Trustees or I could go to the tribunal manuals. So they chose tribunal. They have not approached Central Board of Trustees.
Sorry, we don't want to invest. Really, we don't.
Chief Leadership may permit us.
The mischief is, my lords, all the 4 levels for which the petitioner has not taken a particular ground. Wherein, my lords, in this SLB, they are indicating that
When we propose to dismiss a matter, you will argue at that level. You are inviting a leave granted. Dismissed. Next. Sorry, we don't think we have. They paid the interest that was required.
Interest paid under section 7 was independent, my lords.
That's okay. We don't want to, we don't think we should interfere. Maybe you acted, we don't think we agree with you. Next.
Just one argument, when we permitted.
All right, this council.
Matters over. Thank you.
Matters over. Thank
Next,
you.
36.
Please. But pursuant to the last order, those affidavits have been filed. Before you see the affidavits, I just want to
Just give us a moment. Just open the file, please. File the affidavits, Mr. Nair.
There's an additional affidavit by both parties.
I'm just trying to pull out. Yes.
But before I take your lordships to these affidavits, I just want to
Yes.
put it in context.
Yes, please.
This, in this contempt petition, Lord, this arises out of a consent terms. I just want to show 2 clauses in the consent terms because that will give us, Lord, an idea as to how to approach, Lord, the present issue. So if your lordship would just have the contempt petition, at page 40 is the consent terms.
Page 40 of your additional
No,
affidavit.
of the original contempt petition itself. 499.
Just a moment. Page 40.
40.
40.
Give us some. That's an application, annexure P4, page.
It's consent terms.
Consent terms.
Now, consent petition. Now, which is the first one? Page 40. Yeah, only 2 files हैं. Are we referring to 36 or 36.1? First, come to that.
36.
36.
36. Okay. And you're saying annexure P4.
4.
Okay, consent terms. Which para?
Yes.
Page.
Para 1 describes the flat at 19.1.
Okay.
Now please see para 2 and 3.
Yes, para.
Parties agree and consent to the partition of flats A 1901 and 1902 as demarcated as per alternative 1 suggested by so-and-so in the report dated so-and-so filed in the present proceedings. The petitioner agrees to occupy flat 1902 marked with carpet area 522.
Petitioner meaning you.
Yes.
Okay.
With carpet area 522.5 square feet, respondent agrees to occupy flat 1901 marked with carpet area 521.6 as per alternative 1 in the report dated.
How will this help you?
I just tell you
To make your point.
the point is this: 1901 and 1902 are not of the same area as per the sale deed. There is a difference. But the
522.50, 521.60.
yes, they're equal.
Then,
The division was equal. Just keep that in the back of your mind.
okay.
And then kindly come to 42 para 7.
Yes.
The parties agree to continue to pay their respective home loans as per the existing arrangement. That is, petitioner will pay loan for loan account pertaining to 1902 with loan account number so-and-so, and respondent will pay.
So you are saying each one was supposed to service their respective loans.
Respective loans and a deed.
1901 by you, 1902 by them.
Correct. So that was a rough 50-50 division in terms of area. The sale deeds and this is in consonance with the sale deed when they are both equal loans. Now, why is the controversy now as a reason? During the course of this contempt, it transpired that we should try and sell this land and try.
That's right. That's right.
Now the question is how to divide the proceeds. Our submission was that the flat will be sold. We will take our respective shares and
Now the flats have been unified.
no,
They still remain separate.
they are unified in fact, they are unified. In fact, they are unified, but for the builder rewards for the purposes of stamp duty, etc., they split it up into 2.
So as a matter of fact, they are to say it. The impugned order records that they called the assessing department of the municipal corporation. The municipal corporation took the stand that no, it is two separate flats, etc. But so on paper there are two flats.
Understood that the walls,
One door and one kitchen.
walls have, exactly, so the walls have been removed internally and all that, so it's a one single flat from inside. So you can't sell it separately, that's the point.
The partition was to actually make it 2 units.
Quite.
Out of that. So if it will be sold, they may be on paper 2 deals.
Understood, but in reality, on ground, is only one.
Will buy to occupy that one.
Collectively.
And opposite unit. Now, where is the issue, my lord? The issue is we have said that we sell the flat, whatever the modality, the amount, let's say 100 is the value. We will take our equal shares. And as clause 7 says, we service our respective loans. Whatever my outstanding loan is, I'll get into the numbers later. Whatever my outstanding loan is, I will take care of. Whatever his outstanding loan is, he will take care of. That is a straightforward way of it.
Okay.
His submission is that no, we will sell the flat, we will first purge the liabilities, and then whatever is left over, we will share.
Divide. Understood. You are saying it goes against the spirit of para 7, that's it?
That is one.
Yes.
Secondly, as a matter of fact, I paid a higher down payment, he paid a lower down payment. His interest component is more, my interest.
But we don't want to go into it. If there is a para 7, he has to get around it and let us see what he's saying. Let him respond. Let me quote the second law. Yes, please.
My ladyship and my lordship, last 3 hearings, the same argument has happened. And what the court has also inclined to is that the consent terms,
Inclined is still in our mind. We are not inclined.
Okay.
If that was the case, you wouldn't be here.
the consent terms are for temporary partition of the flats. It was not for dividing the flats permanently. She was to occupy the flat, I was to occupy the flat.
Occupying is one part. Servicing home loans independently.
I have been servicing the
So
loan
you did
for-
it yours, she did hers.
Yes.
That was clear.
But my loan part is 60%. My simple submission is, if she is claiming 50% of the asset, she has to equally bear the liability also.
Please. Flat number 1901 was for her. Flat 1902.
Ladyship, flat number
1902 went to her.
1901 was actually the.
1901 is yours.
Yes, it is actually
Right?
area is 60%. I took the loan for 60%.
We are not on 60% now. It's an independent flat on ground. Whether you divided and partitioned it, whichever way, it will be sold as a composite thing. So whatever it was, 60, 40, doesn't engage us. Please focus on what we are saying.
My
It may be that subsequently the terms have changed because you finally parted company and all that was not required to be done by you all staying there. Point is, even when you did arrive at a settlement, it was clear that she will continue to service the loan qua her and you will continue to service the loan qua you. So why will you club it? There's no question of clubbing it.
Till the time the partition, the final partition of the flats, which was an issue pending before the family court in divorce petition, gets decided. So the actual division of the flats was.
The spirit of the agreement was each one will continue servicing their respective loans.
Absolutely.
Then
Yeah. But the division of the flats.
when you sell it, no division happened, nothing happened. When you sell it as a composite whole, the value will go half and half. She services her part out of it. You service yours. What's the problem?
My ladyship, that will be unfair because
Why will it be unfair?
I'm telling you, because I have already contributed around 60%.
You may have contributed, but that is your choice that you chose to enter into an agreement saying you will service your
In fact,
loan, service.
that was the reason last time affidavit was asked to file on.
Whatever the reason was, there is clarity in our mind now that this clause showed that you were both ad item, that you will service your respective loans. It had nothing to do with the composite or the non-composite part of the flat. It was to do with how you will disburse the amounts and return the loans and pay your EMIs. Now, the point is, say flat is composite, it will be sold, half and half proceeds given to both of you. You will service your loan, she will service hers. Whatever the consequences are, that's it.
My ladyship, just 1 minute of indulgence. Last time also when the same thing was being argued, the point was the consent terms of a temporary partition. I agreed for it because I was supposed to be staying next door to my daughter. She did not stay there. The entire purpose of the consent terms were defeated because of that. The actual division of the flats was to be done in the trial, basis the contribution. There are affidavits, sworn affidavits, where she has relinquished any claim on 1901, which is 60% area. That affidavit is also a part of the record. It's annexed as Annexure A3 in MA 2450. So if you go by that as far as sale deed is concerned, I'm absolutely fine servicing the loan for 60% of the amount, as also getting the asset for 60% of the amount. Kindly see page paper book MA
Are you
245.
bound by the terms of the settlement, please? That's what we have to see. The consent terms are signed by you with open eyes, no dispute.
Sir, I'm not disputing that. In fact, I have paid all the EMIs till now also.
Yes, that's your obligation. You're not.
The only thing is, if she is
Pricing
claiming
anyone
50%
pricing.
asset, let her also share the same liability.
No.
Take them. Sorry.
The another point
We
is,
want to bring a closure to this. You've already parted company. Now put this to an end. Take your monies respectively, 50% of the entire composite flat, and do what you have to with it. You service loan, you do whatever you want to, you keep it. That's entirely your discretion. Nobody should interfere in that.
on the nuances, my leadership, there is an outstanding society maintenance she has not paid.
That will pay, but that is all.
And the other thing is, irrespective of whatever order
We will record this. We will record this.
this bench passes, let family court who has conducted the trial be appointed to oversee, because there may be few minor disagreements. We don't want to knock
I
on
have
the
a
doors.
suggestion. Someone has to oversee. I'm not disputing
Yes,
that.
that's right.
But the property is in Mumbai.
Yes.
But the family court in Delhi to
No.
oversee.
Delhi question doesn't arise.
May say
Question doesn't arise.
their master or anybody nominated by him, because he may be too busy to do that.
Yes.
But someone under the aegis of the Bombay High Court, who can supervise this thing. Not because for someone sitting in Delhi.
No, that's not possible. That's not possible. That is not.
Again, I will on that part say that it is, and I leave it to the fairness and judgment of this honorable court, the consent terms of a temporary partition.
Please, that's over. Don't repeat yourself. Take down.
My leadership, last thing.
That's all, Mr. Jain, sufficient. Thank you.
Not on the flats, my lordship, it is on something else to just put the quietus.
No.
on the-
What is the scope of the contempt? We cannot go beyond the contempt, can we? What is the scope of the contempt? Non-compliance?
I agree.
Non-compliance of which order? Mr. Rai,
12/11/2018.
12/11, come to that 12/11/18.
18 or 19?
2/11 or 12/11? 12/11. 18. Come to 12/11/18.
12/11/2018.
Okay. Let's see that order.
Page 51 of that contempt petition.
No, but this part, come to the order.
Yes.
In addition, we consider it appropriate to direct expedite, that's over, right?
That's done.
Within 6 months, further respondent shall commence construction.
That
Respondent.
never happened. That was actually my contempt.
Okay. So that's over.
Yes.
So we only have to take our order, which we pass saying we're taking on record the subsequent events.
Yes,
Which one is that? Come to that order.
Yes, that 2022 order.
24, which order? 11/7?
29/2/2024.
29/2/2024. Okay, let's take that because that will give us a recall. 29/2. Yes.
It is stated that during the pendency of the proceeding, decree of divorce has been granted by family court Patiala House. Marriage of the parties stand dissolved. Decree has attained finality. The issue is
Okay.
with this flat. The records reveal on the basis of the orders passed by this court on
So mediation did not succeed, right? Take down. By order dated 29/2/2024, both the parties had agreed. It was recorded that rest of the disputes between the parties were resolved in as much as a decree of divorce had been granted by the Family Court Patiala House, New Delhi on 3rd of October 2023, which has attained finality. The lingering issue was in respect of left to be sorted out is in respect of flats number 1901-02. Mention the details of the address from para 3 of the same order, owned by both the parties in terms of the sale deed executed in respect of the said flats. Full stop. Though the parties had agreed that the flats would be disposed of in terms of the consent terms signed by the parties on 29th October 18, the same did not take place. As a result, parties were referred to mediation, but a settlement has not been reported. Full stop. Say that we have further proceedings were taken limited to the aspect of sale of the subject flats to enable the parties to and division of the sale proceeds between them. Coming back to that consent term, say clause 7 of the consent term, PDF page 637, I'll have to go back. Annexure, P4,
P4, 42 of the paper book number.
page 42. Say that clause number 7 of the consent term executed by the parties is extracted below, reproduced from PDF page 90. It is apparent from a perusal of the aforesaid consent terms that both parties had agreed to service their respective home loans. Full stop. The petitioner wife was to service the home loan in respect of flat number A1902, whereas a respondent husband was required to service the home loan in respect of flat number 1901. Full stop. We say that therefore in the spirit of the very same consent term, it is deemed appropriate to direct that the parties shall sell the subject flats which are on ground a composite flat with a single structure with a single door entry, and the sale proceeds shall be divided between both the parties, shall be equally divided between the parties. Thereafter, it is for the petitioner wife and the respondent husband to service their respective home loans. The petitioner and the respondent, sorry, I stand corrected. Not wife, petitioner and the respondent shall service the respective home loans as they may deem appropriate for purposes of conducting the sale and finding an appropriate buyer. It is deemed appropriate. There cannot be any LC there.
And so as directing to the Protho Notary that he may nominate someone.
The Protho Notary attached to the High Court of Bombay shall
Senior master.
and senior master is directed to appoint an officer
Yes.
of
There
the
was already a
court.
commissioner appointed for the partition of the flats.
Appointed officer officer of the court to find a suitable buyer to sell both the flats and execute and ensure that the sale deeds are executed in favor of the buyer. Sell the flats at a market rate and the sale deeds shall be executed in favor of the buyer, and simultaneous and to the execution of the sale deed, the sale proceeds in respect of the respective flats shall be paid to the petitioner and the respondent. Stop. The contempt petition is disposed of.
The line on clearing the outstanding.
Oh, yes. At this stage, the respondent submits that the petitioner has not paid the maintenance to the society. All the outstanding dues towards maintenance shall be paid by the petitioner, and proof thereof shall be handed over to the respondent.
And any expense,
Towards 190.
any expenses incurred on selling should be equally borne by
That's
both
true.
parties.
The expenses that are likely to be incurred for all the incidental expenses likely to be incurred for selling the subject flats shall be borne equally by both the parties.
Only two small requests. One is where leadership has said they will oversee that sale. I don't want to put a timeline, but at least expedite.
As expeditiously as possible, preferably within a period of 3 months from the date the copy of this order is placed before the whatever senior master. Senior master. That's it.
The cause list clause is 36.1 and 36.2, which
What
are
for?
his petitions.
For what?
According to me, they should go.
What are they for?
They were for modification of the order.
All the petitions are disposed of in the common order.
There was the SLP for final partition.
Now that's all over. Thank you. The board is over. The court master will give the dates in the other matters as may be appropriate. Thank you. Senior to you. Senior to you.
We have moved obligation for vacation of first day. Your lordship has been to issue notice and deliver today, my lord, but if.
But now the board, we can't do it. Let the court master do that. Yes, 43. 46.
Pension benefits, madam, that announced services, all the pension benefits will not, all the retired teachers, senior citizens will not.
Council court master will give a date.
Some urgent.
We don't run even our board. We let the court master do his job. Thank you.